The law offices of Scoville and Scoville, serving the Sun Coast of Florida for over 35 years.
Hi, my name is Bart Scoville and I'm one of the attorneys here at Scoville and Scoville, and I'm here to talk to you today about estate planning for parents of minor children. This is a topic that's very near and dear to my heart. I have a 10-year-old and a 4-year-old at home, and so I recognize the importance of planning for them, even though most parents like myself are not really contemplating their mortality at this point. But if planning is not done, especially with parents of minor children, the damage that could be caused because of that lack of planning can be quite substantial. Probably the first thing that parents think of when they think of planning for their children is naming a guardian. This is a very important process because without the proper designation of a guardian, the courts have no guidance in who to appoint. This can create all kinds of contention amongst the family members, each one of which hopefully would want to take the children. In addition, if the children inherit any assets of substance, such as life insurance, the home, that kind of thing, unfortunately some distant relative could step up with ulterior motives, not necessarily for the best interest of the child. So that's why it's very important to make sure that the parents name who they want to be the guardian. The second thing is, without planning, the children at the age of 18 will receive all of the assets that they inherit at their sole discretion, and I know that for my family that's a concern. I just don't believe an 18-year-old has the maturity to make decisions with substantial assets. With proper planning, you can give them the opportunity to sort of learn as they go without the risk of wasting those assets. This is done through what's called a testamentary trust, and the testamentary trust, unlike a guardianship, can give the trustee authority to manage the assets of the child well beyond the age of 18. With a guardianship at the age of 18, the guardian has no choice but to turn all of the assets over to the child. With the testamentary trust, what occurs is the trust continues to exist past the age of 18, and you can designate how you want your assets shared out to your child. Fairly common provisions are that they're to be taken care of course, including health, welfare, maintenance. But beyond that, they will not be able to invade principal until, say, the age of 21, which maybe they'll receive 10 to 25% of the principal, which will give them the opportunity to learn how to manage it. Then again, at the age of 25 to 30, they could receive another third to 25% of the principal, and then at the age of 30 to 35 they could receive the remainder, and that would ensure that they will have assets through the majority of their life, regardless of their ability to manage them, and this will also help teach them how to manage them. So those are some of the primary issues with estate planning for parents of minor children. There are other issues as well, but if you are interested in these or any of the other topics I've discussed, you can give our firm a call, and we'd be glad to discuss them further with you. Thank you very much.
If you have any questions regarding the information contained in this program or any other legal issue, you can visit us on the web at www.scovilles.com or call us at area code 941-365-2252. Thank you.